So, for instance, if you go to seek employment and your employer asks, have you ever been convicted of a crime?
Right.
And you've had your record expunged, and you say, no, you're telling the truth. If they go do a criminal background check on you, it's going to come back that there's no record. However, if that doesn't satisfy an employer, if they're not satisfied with the background check that says, you know, there's nothing on your record, they could go online, they could Google Dan Agatino, and something may bounce back that you've been convicted of a crime, and that may be something that you have to address. But for legal purposes, that offense is deemed not to have occurred.
Would you say that this is an area of law that a pro se client can just handle on his own or by herself?
I wouldn't advise someone to try to do this by themselves because it is so heavy in the documentation that you have to circulate with sending a variety of proposed orders, petitions, affidavits to the court.
Let's stop there if we can. What's the difference between an order, an affidavit, and a petition?
The petition is what you're asking the court to do.
Okay.
You're pretty much saying, I was convicted on this date, this was my charge, this was the complaint number, I haven't been convicted of anything since then. By virtue of the statute, I would like, you know, all records to be expunged.
Okay.
The affidavit is pretty much, it's signed by the petitioner themselves, notarized, saying, you know, this is my name, this is, you know, my address, this is my date of birth, there are currently no charges pending against me, because that's a big concern that the courts have. If you have a petition for expungement and the statute is so heavily relies on the fact that you've had one conviction, there's nothing for 10 years, and you come to the court and you're petitioning for an expungement and there's a charge pending against you, the court can't grant you an expungement or really even entertain the application because they don't know what's going to happen with that other offense. You can be convicted of a crime, and that's 2 crimes, and that's an absolute bar. You could, the arrest could result in a dismissal, you know what I mean? And then you can still expunge that conviction. But back to the question you originally asked me, finally the order, there are 2 orders that we prepare to give to the court. The first is the order fixing time for the hearing. That is the order that lets all these government agencies know on such and such date this court is going to have a hearing and entertain this person's expungement petition. The other order that we provide the court is called the final order for expungement. We do the order. It's not the court's problem to prepare an order that says that they're going to be expunged. We draft it. We have the specific language that, you know, pretty much covers all our bases, that these records are going to be expunged and placed with a custodian who is, you know, meant to handle these records. They're not to be released to anyone else. That's what the judge signs. It comes back to us, and then we send that to all the different government agencies so they can clear out their records.
Because I want to educate our audience, and there may be people who are watching saying, I wonder if my conviction is eligible. Can we go through just a few, and maybe if you know if it's something that can be expunged, you could tell us. Shoplifting.
Shoplifting can be expunged.
Underage drinking.
Underage drinking can be expunged.
There are various disorderly persons offenses.
Any disorderly person's offense can be expunged. There are specific crimes that are set forth in the statute that cannot be expunged. Like I said, and obviously some of the more serious ones, homicide, arson, kidnapping, aggravated sexual assault, a lot of the more violent sexual offenses cannot be expunged, those sort of things.
Well, let me ask you this. Say that my harassment charge starts off as a serious matter and then gets taken down to a less serious matter because, as we know, the way it works in New Jersey is sometimes a crime is investigated by the police. It is turned over to a prosecutor. The prosecutor is going to go through the procedures in a superior court and then decides this is not a matter that merits the superior court's interest. Let me send it. I'm not going to make it go away, but I'm going to send it to a lower court.
You're going to downgrade it to the municipal court.
So I downgrade it to a municipal court. Now, it becomes a disorderly person. But the original charge was not a disorderly person. Is that an expungible?
The statute specifically references conviction. So you may have originally been arrested for a crime, but it was downgraded to an offense. So that's the conviction that you're asking that the court to expunge. You haven't been convicted of a crime, so you don't have to wait the 10 years. If you're convicted of the disorderly persons offense, even though it may have started in the superior court, you have to wait the 5 years before you can petition the court, and it's considered an offense.
Okay. But what about the arrests? Can you expunge an arrest?
Yes, you can expunge an arrest.
How do you do that?
The same procedure. You just put it in your petition that you have been arrested on such and such day. Some people are arrested and charged, and the charges are subsequently dismissed.
But there's still a record of the arrest.
There's still a record of the arrest. So if anything was searched, it would come back that this person had been arrested once before. So by the same mechanism in which you would ask the court to expunge a crime or an offense, you can ask the court to expunge record of an arrest.
On job applications, can the question be, have you ever been arrested?
And if you've had your arrest expunged, you can say no.
What about if my crime involves another person? So if I'm doing something like shoplifting, then perhaps there's a store that was damaged, but there's not an individual who likely has been hurt. But if my crime is something like maybe I got into a fight with my neighbor, can my neighbor put in I don't know, objection to this to say, oh, I don't want this expunged. I went to court, I showed up, we got a legitimate conviction, and I don't want this individual to have an expunged record because I feel wronged, I'm glad justice was served, and no, let him keep it on his record for the rest of his life.
As far as my reading of the statute goes and the code, there's no provision that an alleged victim has to be served with any sort of notice. It's just law enforcement, because a victim really isn't going to carry much weight with the court. If they say, look, this was 5 years ago and there was a simple assault, he punched me out, I'm still reeling from it, I think the court's going to balance that against your right to have your record, your right to have the record expunged, and say, look, this person has led a law-abiding life. There's really no reason. I think it's very unlikely that a quote-unquote victim would find out that you were even petitioning the court for an expungement to show up or put in their 2 cents.
So there's no duty to notice the victim?
No.
We only have a few minutes left, and I just want to close our time together by asking you, the expungements that you've done, what would you say is a percentage of success?
All the expungements that I have done personally have resulted in a final order of expungement. And that really depends on how honest the person with the conviction is. If they tell you, this is what I have 1 offense, this was it, and you file your documents and there's really nothing that comes out and surprises you, then the judge is going to sign an order and you'll get a final order of expungement without having to appear. But I found that people who want to expunge their records, it's a very, very personal thing to them. And they really epitomize that, saying that, they've lived a law-abiding life. And a lot of people have been waiting and waiting, the time frame to get this expungement. And they've done everything they can to ensure that they are going to get this expunged. So I think based upon my experience, the more honest people are, the more likely that you're going to be successful in getting an expungement.
We greatly appreciate you sharing this experience with us. Thanks for coming on. And thank you for tuning in to LawTalkToday.tv. I'm Dan Agatino, your host.